Howdy, folks. Welcome to the Texas NORML General Meeting. It's June 1st, 2022. It is our semi-annual Ask a Lawyer night. So I want to thank everybody who is here on Zoom and Facebook and people who are watching on YouTube in the future. You too, if you want to throw in some questions in the YouTube comments, maybe we'll try to come back and answer them. But for now, anybody that's here live can ask questions of any three of us. We are three lawyers. My name is Jamie Spencer. I am legal counsel for Texas NORML. Texas NORML, of course, is one of the major organizations that's been in Texas for a long time, advocating for marijuana legalization is what it comes down to. And of course, we're centered here in Austin, Texas. And Travis County has some of the most progressive marijuana policies in the state. I think that's close to inarguable. However, there are 254 counties in Texas, and it is important that we manage to not just get good things accomplished on the local level, but that we get them on the state level and eventually the federal level as well. Now, there is a national NORML and they work on federal things as well as things here in Texas, but we're pretty much focused on the Texas legislature. And for the most part, if you have attended or in person pre-COVID or watched, since COVID, a lot of times you'll see that our monthly meetings, which are every Wednesday at 8 p.m., that they focus on what we need to do to change the law, because the law itself that says that possessing marijuana is something that should send you to jail, because we are all in agreement that that's wrong. And when I say we all are in agreement, the last number that I remember from a Texas poll is that if you include decriminalization, some form of medical and or complete legalization, Texas was about at 86% of people who thought that marijuana should be legalized, and we are over criminalizing it now. So our main focus here at NORML is getting to the Texas legislature every 2 years. The last couple of years, the COVID year was different, but before that, we've been able to bring hundreds of people, literally hundreds of people to the Capitol on days when we are lobbying to convince the legislators that they should adopt one of these several bills that is generally now in front of them in terms of reducing or eliminating penalties for marijuana. However, tonight, we're going to kind of tackle a different subject. As many of you know, I am a criminal defense lawyer by trade. That's what I do for a job. And obviously I represent a lot of folks that are charged with various drug crimes, including possession of marijuana. You may have heard me in the past talk about when we are talking to the legislature, very often we were talking equitable arguments to them. In other words, hey, it is not right for my clients to have to be prosecuted for this because it's not worthy to be in there. And when you make arguments in court to a jury, that's very different. That would sort of be like jury nullification. You're not allowed to do that. When you make arguments to a jury, you have to tell them, hey, my client didn't possess marijuana, or the state didn't prove that my client possessed marijuana, or in certain what are called 3823 situations, you may actually be able to put a legal issue in front of the jury and say, hey, you should acquit my client because the police didn't act properly. Those are what are called substantive arguments. And tonight, we're really going to be sort of focusing on the substance of marijuana law from the perspective of if somebody is convicted, and by that I'm going to include being placed on a deferred adjudication probation because that's appealable. What are their options for appeal? We have, I'm super thrilled to have two great lawyers here with me tonight, Angelica Cogliano and Rob Daniel. Both of them do appeals on a regular basis. Rob, I believe, is up to about 100% appellate work. Is that right, Rob? Just by nodding and those sorts of things? Or okay, yeah. And then Angelica does appeals and court work as well. But the three of us are going to have a conversation, and we would love to have you chime in and ask questions. But we're going to be talking about the appellate process. Once somebody has reached that level where a judge has signed their name to a piece of paper that says that they have some sort of conviction or deferred adjudication, if they want to continue fighting it, what would they do? Now, in preparing for this, Rob reminded me of a clip from John Oliver from a couple of weeks ago where he was actually, I hadn't seen it, but I would like to, in just a minute here, play a little clip from John Oliver. I call this the Hollywood version of what people think about when they think about criminal appeals. It's really, really common for movies and other media to sort of portray a conviction as if it's really not that big of a deal because you can probably easily get it overturned. If something unfair happened to you during the process, the appellate judges will be able to see that and those sorts of things. Stephen, if we're trying some new IT stuff tonight, let me see if we can pull off playing a few clips of how Hollywood tells people the appellate process works.
There is a remedy for wrongful convictions built right into the system.
The fight that's on appeal, it isn't over.
I'll get the conviction overturned on appeal.
Of course, I'll be appealing.
I'll appeal this all the way to the Supreme Court.
We will appeal this.
Don't say a thing. We'll appeal.
Okay, hold on.
All right. So, and just in terms of context, John Oliver was on the same rant that I am, in the sense that despite where it popped in there, he was saying that this is what people think about the appellate process, or at least this is how popular culture treats it. And tonight we're going to kind of dig into it a little bit more. Basically, I'm going to throw out a couple of ideas, and then I'm going to ask my two awesome guest speakers to comment after them. Sticking on the Hollywood train for just a little bit. And Rob, I'm just going to tell you, we're leading up to the Amarillo story. Anyway, Better Call Saul. I know everybody out there loves Breaking Bad, loves Better Call Saul. So do I. I'm sure if doctors watch ER or some other medical drama, House or something like that, they probably have little mini heart attacks watching these doctors totally screw things up. Well, we don't expect the trial process and those sorts of things to be accurately depicted on TV. But if you've seen those shows, you've seen Saul Goodman basically rush into a police station, apparently past everybody, waving his briefcase and shouting, the Constitution says I'm going to sue you for $1 million if you don't let me into that room and let me talk to my client. And then he goes in and he threatens the police officers. And he tells them he's going to sue them too for harassment and all of these other sorts of nonsense things, right? The first thing I'm going to bring up is literally sometimes when you are working on an appeal, and this could be true if they're just in jail initially as well, how literally difficult it is sometimes to be able to get in and see your client. And Rob, I think Rob has a little story about some time that he had to go to Amarillo and ran into a few of these roadblocks we're talking about. Rob, you want to expound on that?
Yeah, sure. So I do a lot of appeals and post-conviction work. And so a lot of my clients are already convicted and they're in prisons, so TDCJ units. And one of the big units is the Clements unit in Amarillo. And I needed to go visit a guy up there. And if you drive to Amarillo from Austin, it's not a very interesting drive and takes about 9 hours. So I flew on an airplane. And I realized when I landed at the airport that I had not reserved a rental car. And in my brain, I thought, hey, this is a smaller city, no problem. I'll rent a car, walk across the parking lot and drive out to the unit, which is kind of unusual because the Clements unit is very close to downtown Amarillo. Well, it turns out that nobody can rent a car at the Amarillo airport. Even if you've made a reservation, it's like that Seinfeld episode where they have the reservation and they don't get the car. So, I think to myself, okay, plan B, well, I'll take an Uber or Lyft out to the unit. Then I realize that's a problem because I have my laptop and my cell phone. And of course, you can't take those things into a prison without committing a felony. So I call the unit and I asked them what to do. And they basically said, don't show up here with your cell phone. We won't let you in. So we moved to plan C, which was to call a colleague, Brian Johnston, who works in Amarillo and is a criminal defense lawyer. And I hadn't seen Brian in about 8 years probably, but he was nice enough to let me borrow his car and drive out to the unit where I met with my client, drove back, and then Brian drove me to the airport and I flew home. Not, we made everything work, but, one glamorous day in the life of a criminal defense attorney, I guess.
And Angelica, I'll just throw it out there. I didn't pre-get this with you, but do you have any stories about literally difficult physical access to clients, whether it's in an appellate situation or, the instant case?
I guess just the pandemic, we weren't allowed into prisons for a long time in the pandemic. They made phone calls a little more accessible because of that, but, largely it caused a lot of problems when you needed to get things signed or you needed to talk confidentially with potential or current appellate clients. Not being able to see them was a big problem.
Right. And again, part of this, look, bringing this up for two reasons. Number one, sort of the general idea that as lawyers, that the sheriff's deputies, that the prison officials, that we whip out that bar card and they start doing as we say. That is not how you see those smiles. I got some smiles out of the lawyers there on that, because again, that's the Hollywood one. But maybe more importantly, the reason that I liked Rob's story when he told me that a couple of days ago, wanted to bring it up, is I think in some ways, Rob trying to go out to see a client in a prison to see whether or not, he's going to do his best to help this person who's in prison and figure out, is there something we can do so that you're not in prison or reduce your sentence or whatever the situation is. It doesn't matter. He just wants to be able to communicate with that person, right? That's a very basic issue. And I think that there's a good analogy between that and how the appellate courts, I'm going to use air quotes, intellectually approach our clients' cases on appeal. They don't want to hear what the issue is that we are bringing up. And the reason is that they're embarrassed to affirm a conviction when a lawyer shows them on appeal that something tremendously has gone wrong here. So what they've done over time is they have constructed this labyrinth that you have to get through so that they can try to trick you out of not being able to get your client heard properly. Yeah, I guess that's part of my theme. I've got it here in bold on my notes. The Texas and federal appellate process is intentionally designed to prevent anyone convicted of any offense. This isn't necessarily a marijuana or drug issue, of having their substantive case heard. Rob, I'm curious to what extent you agree with me on that, or that you would tweak that, or what sorts of experiences you've had with that.
Well, I think the lesson of the clip that you showed is there's this idea that if something unfair happens in the trial court, then it can be corrected on appeal. And by and large, that's not true. And I think there's, in theory, at least a good faith reason for that, right? What we want to happen in the criminal justice system is that everything happens the right way in the trial court, and we don't get convictions reversed because, hey, no problem, right? But, the three of us doing what we do, we know that that's not always true. But your best shot to win is at trial, usually. If you lose at trial, the way that the appellate courts are going to analyze your claims, which necessarily have to be, for the most part, the same type of claims you brought in the trial court. They analyze them with, I guess, a lot of scrutiny. And if you lose your appeal, you can file what's called a post-conviction writ, but then your odds get even slimmer. I've heard one lawyer who does all types of cases say that you've got probably, tell me what you guys think about this statistic, like a 1 in 3 chance of winning at trial. And then when you get to your appeal, we're talking about a less than 10% chance of getting your conviction reversed on appeal. And when you get to post-conviction, it's less than 2%. So I agree with Jamie that the appellate system is not designed to correct miscarriages of justice. The idea is that we're going to do that in the trial court, and then the Court of Appeals is mainly going to analyze technical issues about what happened at trial afterwards.
Angelica, what are your thoughts?
Oh, just largely the same. There's this legal kind of fiction that Rob talked about, which is the weight of the need to have faith in the trial courts, right? And this fear that the Court of Criminal Appeals has and cites when it's talking about, you know, its policies on whether to take cases or not, which is that people need to have feel that whatever happens in a trial court is going to stay, because, you know, in a vacuum, the idea that you need to believe in what happens in the trial court and that needs to have a final resolution for victims is, you know, a good, you know, lip service and a good, you know, selling point for not reversing cases. But really what happens is they, as Jamie said, desperately find ways to not even consider the issue. It's not even that they're ruling against the actual legal issue that you're raising a lot of the time. What they'll do is say that it wasn't, you know, harmful error, or just, even if you just didn't enter that piece of evidence, it doesn't mean the whole case would have been different, or that wasn't preserved. The attorney didn't object enough or in the right way at trial. And so we can't, you waived that issue, right? And the state never waives any issues, only the defense waives issues. And so really it's just, they, you know, they have good phrases and, you know, ways to sell what they do. But the truth is that they just don't want to give defendants the opportunity to show that something was wrong in a Texas court.
Right, and I think both of y'all touched on something that all three of us kind of think about. I'm going to do something. I'm going to try to say what I'm about to say in lay language, for lack of a better way of saying it. And that is, this is something that I'm absolutely convinced that the public is basically unaware of. There may be good reasons for it, but anytime you're looking at an appeal, you have to realize that the appellate court starts off, they don't start off even, but 50-50 between these two people. A lot of times I think people think, well, the appellate court's kind of going back and weighing and what looks right and what looks wrong. No, they start with, if you won already, then we are going to interpret everything in your favor. And that's actually essentially the standard when they look at appeals to start off with. You know, so it's not this reweighing of evidence and those sorts of issues at all. All right. I tell you what, this is one that I don't know. I think this would surprise people. I guess of the two of you, either one of you raise your hand or jump in if you want to talk about something ridiculous like font size. And those, look, guys out there in the audience, I just said font size and two appellate lawyers laughed. Angelica, why did you laugh?
In all honesty, I laughed because there's some font choices that I feel like attorneys make that honestly, I just think it makes the briefings look funny. And I'm in a feud right now with somebody in my office about fonts, because she's been taught that you can like use different fonts in different sizes, and that makes it more persuasive to an appellate court. And I think it makes it look like you don't know how to keep the same font throughout the whole document. So, you know, that's not, I don't know if that's what you were looking for, but that's what's going on in my brain right now.
And the reason I laugh,
what's the best font to use and how do you, you know, and it's like, I don't know.
And Rob?
Well, the reason I laughed is because Angelica's colleague, if you did that 15 years ago, the Court of Appeals would write you a letter saying we're striking your brief because you didn't comply with the rules of appellate procedure. Things are a little bit more lenient now, but if you look at the old rules, I think originally with electronic briefs you were required to use Times New Roman, and it was required to be 13-point font. So,
and I should throw in here, by the way, I do believe that my last appeal was in 2014. I'm like the little kid that sinks a three-pointer at the basketball court and then takes his ball and goes home because I won my last. I never won. Then I won 2 appeals in 2014, and I haven't done any since. But I'm actually am glad that they got rid of the font size issue, but there are still things like that, right? Aren't there things that are almost as ridiculous that they'll reject you for? Or are they doing better on the filing now in terms of saying, okay?
Yeah, I think, there's been a little bit of a shift in appellate courts and courts generally to where, they go, hey, we're not going to, pour you out on some technicality. We're at least going to give you a hearing. And so, like, particularly with pro se defendants, instead of just being like, you didn't follow the rules, they'll give you an opportunity to correct your mistake by explaining you broke the rules and you need to fix it within 10 days. But, we have all sorts of things that, the Texas Rules of Appellate Procedure, it's abbreviated TRAP. And the joke is that that's on purpose because, that lay all these traps for you. We've got word count limits. You have to have certificate of service. And yeah, if you don't comply with that stuff, or, if you leave the table of contents out of your brief or a statement of facts, then yeah, they'll still not file your brief.
All right. So kind of same topic, but moving on slightly. I remember from law school, a lot of times when you're assigned a bunch of cases to read, it seemed like, you would read case number 1 and the prosecution one, you read case number 2 and the defense one, and maybe it wasn't exactly 50-50, but you certainly, you didn't have any idea of all these appellate cases that you're reading, what the sort of percentages were. So it took me a few years into my practice, and I'm sure somebody explained this to me already. I don't think I came up with this, but a few years in, I felt like that the mid-level, the courts of appeals, pretty much just went with a standard template on all cases. Part of this really is due to the drug war, right? The drug war explodes in the 70s and 80s and 90s, and they literally just don't, if you keep putting more and more people in prison, you're going to have more and more appeals. If you have the same number of people working on the appeals, there's only so much time they're going to spend on them. So what they did is they came up with a 3-part template. First, they wrote some paragraphs that said why what the defendant was complaining about was not error. And then they wrote some paragraphs and said why, even if it was error, the defendant waived it because the lawyer did or didn't do something. And 3, they would then say, hey, even if it was error and even if the lawyer didn't waive it, it was harmless error. Now, harmless error is one of the biggest disasters in terms of real intellectually thinking about, are we going to look at cases after their convictions and try to figure them out or not? Does either one of you two want to do a better job than me of trying to explain harmless error, Rob?
Yeah, I mean, the idea is that it's okay for mistakes to be made at trial. So the judge can make mistakes, your lawyer can make mistakes, the prosecutor could even make an improper argument to the jury or something. But those mistakes don't matter unless they make the trial fundamentally unfair. And so, not to get too technical, but there are 2 types of harm analysis, and they're both really bad. If it's a constitutional error, then the Court of Appeals basically, constitutional error is not so bad. They have to find that beyond a reasonable doubt the error did not affect your trial, but most errors are not constitutional error. They're like, your lawyer made a good objection about whether evidence should be let in, and the court made the wrong ruling. With something like that, the court has to affirm the conviction. They have to uphold the conviction unless they determine that, you know, the mistake rises to the level of unfair harm. And 9 times out of 10, probably, 99 times out of 100, they're not going to find that non-constitutional error is harmful.
Well, Rob, let me jump in and ask you this. I'm your client, I'm a defendant. You're explaining this to me. Are you telling me that we know, for whatever reason, that we have a good argument that they shouldn't have allowed XYZ in? However, for me to prevail on appeal, I'm going to have to show, I'm going to have to prove that if XYZ hadn't been there, I wouldn't have been convicted. Is that what you're telling me as the lawyer? Essentially?
Yeah, basically.
And then my next question as the client is, how do I prove in a hypothetical? I mean, in theory, couldn't you say this is never provable? I know I'm going a little harsh here, but I mean, you talk about trap. I have to prove that if something didn't happen, the result would have been different. That's the standard.
Yes.
And yeah, I do know that, even though I sound frustrated at you pretending that you're my lawyer, by the way, but okay.
Well, hey, I'll be your lawyer anytime, Jamie. But, and I think it gets very frustrating because you'll see these appellate court opinions where the Court of Appeals will basically say, well, the jury wouldn't have bought that. Well, if that evidence had been kept out, they still would have done this. But
right.
me as an appellate lawyer, one thing I'm not allowed to do is go ask the jury.
Right.
What a great point. Thank you. Right. There would theoretically be ways of figuring this out that would at least make some sense. So if they really wanted to know, right, there might be something that we could do. But thank you for bringing that up. Mm-hmm. Right. You can't go back and ask the jury, hey, if we hadn't, let in all of this evidence of XYZ, and now we know that that's false, or whatever reason it is, would you have done it differently? Not even allowed in my appeal, right? I can't. So I have to prove the jury would have done something different without you being able to say what the jury would have done.
Right. And even if we know the jury did rely on that, right? The idea is, would a reasonable jury have done that, whether or not the jury that convicted the person did? Right. And we just had a recent trial where there was jury questionnaire sent out after the verdict was over, just asking what the jury thought was, persuasive or not persuasive. And they said the worst evidence against the defendant was that he didn't testify. And, we all know that the defendant has a right not to testify. They get told over and over again that they can't use that against the defendant, that they can't be a juror if they will use that against the defendant, that they can't even consider it when they're talking about in their deliberations. And here we have a piece of paper that the only thing he wrote on the whole questionnaire was that he convicted this defendant because they didn't testify. And we can't do anything, right? We're trying to find some creative way to deal with it. But the way that you would think you could deal with it is appeal and say this juror didn't follow the law and he convicted our client despite his Fifth Amendment right under the Constitution, and we can't, because, you're just not allowed to raise that in a direct appeal situation.
In a scenario where you're supposed to prove, you must prove what that would tell you, you're not allowed to bring it up. And I mean, I can remember at least one talking to a jury, a particular juror after a case where maybe they don't use these words, but they do literally in a few minutes after the guilty verdict, they say, man, I really wish I could have heard from him. That might have made a difference. They'll just openly say that stuff. I can't come in and testify that they said that. They can't do that. All right. And let me ask you this. When you're talking about harmless error, I don't want to get too much in the weeds here, but for example, imagine a scenario where you ask for a strike. You're in jury selection and you think somebody should be struck for whatever legal reason, for whatever opinion that they stated that makes them ineligible to be on this jury. The judge disagrees with you. And then you end up, I know this never happens, just hear me out. You end up with extra strikes So you get to use your strike on that person anyway, right? I can see a scenario that absolutely makes mathematical sense, that yes, the judge should have struck that juror, but the juror didn't make it on the jury and you still had additional strikes, right? There are at least hypothetically scenarios where you could have error that didn't affect things, but they go so far out of their way in the other direction, with the standard. All right. Let me check really quickly. I don't see a bunch of stuff in chat. Stephen, if you're transferring it over, I'm only seeing the Zoom stuff, so I'm not seeing any questions for us right now. I do have kind of at least one last little thing that I want to talk about. I think some of our audience may have seen headlines recently, and I actually went and copied some of these. The Supreme Court just said that innocence is irrelevant. I think that I would have a tiny nitpick with that as a headline. But what about this one? The Supreme Court just said that evidence of innocence is not enough. I know we haven't had necessarily a lot of time to take in this opinion, but do either of y'all think that the Supreme Court just said that evidence of innocence, how about if I throw in, is not always enough to reverse? I mean, is that a fair statement of the law where we are right now?
So is that the new one that's about ineffective assistance of counsel?
It is. That's right.
I think that what that turned on is whether you can add new evidence into the record for the court to consider. So, it's basically
it did. It absolutely did. But I'm talking from the public's perspective of, hey, I know you've had new evidence before AADPA, all that kind of stuff. I don't necessarily want to get in the weeds on that, but we are talking about, yes, let me just throw this out here. The issue of finality is what the state always wants to talk about, right? Ted Cruz, famously as Solicitor General for Texas in about 2002, there was a person who had 2 prior misdemeanor thefts, and now they had a 3rd misdemeanor theft, which enhanced it to something called a state jail felony. And actually, the case that eventually this turned on came out of Bob Perkins' court. There was some confusion in the law about whether or not that state jail felony could also be enhanced all the way up to a 2nd degree. It came out that at the end of it, no, it's supposed to only be a maximum of 2 years. Your 3rd time stealing, you get a maximum of 2 years. If I remember correctly, the defendant was sentenced to 18 years under the theory that it was 2 to 20. It was like 16 or 18 years. And then 3 or 4 years into his prison sentence that he is currently serving, Ted Cruz, Solicitor General for Texas, is in front of the Supreme Court arguing exactly what I just said, that this person should have gotten a maximum of 2 years. There is no doubt about that. They didn't try to hide that because there was just no way around it, but that he'd had an appeal and however he'd exhausted the appellate process. I don't remember the exact labyrinth in that one, but he'd had his chance. So even though now we know he has already served 2 times as much time as is the maximum for this offense, Ted Cruz is up there saying, hey, let's let him serve out the other 14 years of the sentence or whatever it is. Thankfully, the Supreme Court did the right thing on that one. But I think that's something that's insanely crazy that the public needs to know about. These are the sorts of things we're talking about. Finality, we want, and it comes from the death penalty. We want to kill this person, and if we let him keep appealing, we'll never get to do it. We cannot let him die before we kill him. And between, severe death penalty advocates and the drug war, I think this is where we've gotten ourselves. Any comments?
Yeah, so finality is a big thing for a lot of courts. And Jamie's absolutely right about that. I think if we had a prosecutor here, well, first of all, I think Jamie's right about where finality comes from. I've heard some prosecutors say, well, this is the flip side of what you guys get with a not guilty verdict. That because of double jeopardy, you never get to try the guy again. If we get a conviction, it should be final and we should respect what the jury did and all that. But if we look at sort of the overall criminal justice process, you start with trial, and then everyone in Texas, at least, has the right to what we call a direct appeal. If you lose that, you can file a post-conviction application for writ of habeas corpus. And when it comes to that, we have what we call a 1 bite at the apple rule. means you only get one. And the only way you can get more than one is if something comes up that you didn't know when you filed your first one. So let's say the state is withholding evidence and someone spills the beans after you lost your first post-conviction appeal. Then you can bring a second one. But let's say Angelica gets convicted and she's sitting in TDCJ and Jamie writes her a letter that says, I'm the person who did the crime. And Angelica never tells her lawyer about that. And he doesn't include an actual innocence claim in the post-conviction writ. In theory, she couldn't bring that up later. Well, in more than theory. I mean, the rule says if you knew about it at the time you filed your first writ application, you're out of luck. And so, finalities, we have rules that basically are designed to make convictions final. And if defendants don't assert their rights, at every stage as best they can, then you stand to lose a lot.
Right. And what the Court of Criminal Appeals has done along with that rule is develop this other rule that, it's called Latches, and it's not codified. It's not part of our statutes. It's not written anywhere in anything that the legislature has passed, but the Court of Criminal Appeals has decided that they're going to use this idea that's historically founded in a very different area of law to say, well, on the one hand, you only get one shot, which makes you want to wait and see if other evidence comes up before you file it so you don't lose that shot. And then they have Latches, which says, well, you can't wait too long. And we're not going to tell you what's too long because it doesn't really mean any specific amount of time, but it's so not fair to the government if you're going to be raising issues so long after you're done with the conviction. And so they take away this opportunity from defendants on both ends. On the one end, they're saying, don't file right away because you only get one shot. And then on the other end, the federal government saying, well, you only have 1 year to come to us. And the Court of Criminal Appeals is saying, and if you wait too long, even if we totally agree that you absolutely had error and you absolutely should have this reversed, because of this theoretical idea that exists in law, we're not going to hear your case. And they've said that straight up. They've said that they agree that the person deserves relief, but because of this Latches, which is not codified, it's not written in any law, they're not going to hear it and they're not going to reverse it for the individual that they agree was wronged by our legal system. And so really, like Jamie's saying, this idea of finality, this idea of having faith in what happens in the trial court, they weigh that very, very heavily over pretty much anything that is in the interest of the defendant.
Yep, oh, sorry, Jamie, you're muted, I think. But I was just going to say, the rule is essentially if you go too fast and leave something out, you're screwed forever. If you don't go fast enough, then you're screwed forever. And so that puts us in a tough spot where, as appellate attorneys, we need to thoroughly investigate claims that we want to raise in post-conviction appeals. But we have these time limits that we have to be aware of as well. So.
All right. Go ahead, Angelica. Sorry.
I was just going to say one thing, just to be aware of is actual innocence claims are very scary to the state, because if you're found actually innocent, they have to pay you a certain amount of money for the amount of days that you were incarcerated. And so we've had cases where even the prosecutor and the trial court agree that this person is actually innocent, and the Court of Criminal Appeals will find a way to change that finding because they don't want to expose the state to the statutory remedy that people are entitled to if they're actually innocent of a crime that they spend time in prison for. And so that's a consideration that's not codified either, but obviously very, very real.
It is absolutely real. I think there's something much more valuable to the state, which is actually what you already said earlier, Angelica, and that is the blow to the idea that wrongful convictions don't happen in the first place, right? The idea that somebody spent 20 years in prison for something that they didn't do is not something that is supposed to happen in a beyond a reasonable doubt kind of world, not with the frequency with which it does. So to some extent, it's all their other trials where they just have to hope that you just believe whatever the police officer says or whatever the particular situation is. And I'm not saying the one or five, the few $1 million doesn't make a difference. It absolutely does. And that's a motive as well. But if you could put a number on the state's desire for just believe we always get it right, they would pay unlimited amounts of money for that. All right, so we've got a couple of questions in the chat. I'm going to take a stab at the first one, and then I'll throw the second one out there, and I'm going to take them in reverse order. The first one is, what is the difference between having your charge sealed versus expunged? Jessica, thank you for the question. So sealed is typically something called a motion for non-disclosure. That means that you went in front of a judge, you told the judge that you were guilty. The judge said, hey, you're standing here in front of me. I could find you guilty, but I'm going to defer adjudication. I'm going to postpone finding you guilty. And if you jump through the hoops of probation, just like my convicted probation court attendees, then at the end, you won't be convicted. A lot of them say it's going to be dismissed, but that's not in the way that the public thinks of it. And so then after sometimes a waiting period, you're allowed to go back and make it so that only governmental entities have access to the fact that you did, for example, in this case, a marijuana probation. And expunction is, you can only get what you can get. If you have a deferred adjudication probation successfully completed, that's all you can get. But if the case is legitimately dismissed up front, maybe you did some upfront hoops, took a danger of marijuana class or something like, and did some community service, you get it actually dismissed where it's just between you, your lawyer, and the prosecutor, and the judge isn't involved, then you're probably eligible for an expunction. And the beauty there is, man, there's a lot of governmental agencies. For example, you have kids and you decide you want to be the assistant coach, and Austin Independent School District runs criminal history. They'll probably let you be coach or assistant coach or whatever thing that you're applying for, but they will know that you did deferred adjudication for marijuana when you were 23 or whatever it was. So expunctions are always better. Hopefully that answered the question. If it doesn't, please do another one in chat. And then I think this last one is almost maybe a great way to almost wrap it up. Angelica and Rob, can you read Mark's? I'll read it, but I'm asking, have you seen it?
Yeah, I can see it.
Okay. So this is super interesting. And Mark, if you want to put this in chat, I wonder, normally I wouldn't call somebody out here. I was talking to Dave Bass, who is our former Veterans Outreach Board of Directors member. And he was telling me about someone that had exactly your situation, Mark. So I'm going to read your question for the YouTubers and stuff for later that aren't able to see it. Hello, my name is Mark. I have a few medical conditions, including PTSD from the military. I was given a prescription from my doctor for low-level THC last year. I'm also on misdemeanor probation from an event stemming from 2018. I gave my probation officer my prescription and she sent me to the judge, who basically said I could take all my medication except THC. My question is there any legal recourse so I can have access to my THC medication? Thank you. This is in some ways, way too long for us to be able to answer in a, we're not giving you specific legal advice. We're talking generically and those sorts of things, but you bring up a whole bunch of different things. The first thing that I'll throw out before I pass it on to my buddies is that what we're fearing here is that on a urinalysis, your probation officer will write up a few pieces of paper and send it off to the clerk of the court and say, I'm upset with Mark. I believe he's violated probation. I think you should revoke his probation and put him in jail because he came back for THC, versus you're saying, hey, there's THC, there's Delta 9, Delta 8, there's ways that I can get this from something other than illegal marijuana. The first thing that I always tell people when they're asking me this sort of question, which I think is perfectly reasonable, and I just want to make this really clear, even if I don't solve your problem, I think that your problem should be solved. Drinking alcohol if you're over 21 is not a criminal offense. but there's no question they can ban it on probation. So unfortunately, and by the way, that means if you go on shoplifting probation, the judge can stop you from drinking alcohol during that and make that a violation. I don't think that with a lowered standard of probation revocation is not beyond a reasonable doubt. I think that in court, if what you're worried about, if the you-know-what hit the fan, I think that you would have a difficult time here. I think a lot of judges would potentially revoke you. And Rob and Angelica, if you can tell me what you could do to, appealing it for, I don't even know where to start. Any other ideas about what you can do in a situation other than finding a lawyer who knows what they're doing, that can go talk some sense to the prosecutor and the judge? I don't know where you are.
So I think what he's referring to, and maybe I misunderstood, is if they're part of the compassionate use program and they have
That's right.
actual, right.
They do. That's right.
My guess would be what Jamie's saying is that everything cuts against the defendant. I haven't dealt with this personally, but they can decide, for example, when people are in jail, what kind of medicine they can be on. You really don't have any freedom anymore once you're on probation, but that being said, I would have to expect that a good lawyer would come up with some sort of litigation strategy to deal with that up front, that, you're being prescribed something by a doctor and the court's trying to, our legislature has created this opportunity for people. They have legalized this medicine and allowed this medicine, so, I'd be hopeful that a lawyer would be able to litigate that in a way that would protect you. I'm answering both ways at once, but 9 times out of 10, my hope for that is not accurate and doesn't play out the way that I would hope the court system works. And, when you're a probationee, you don't really have any rights anymore, unfortunately. It's not how it should be. It's not right, but that's how I've experienced the Texas legal system.
Rob, any thoughts on that?
Yeah. So to say something different, I guess, because I agree with mostly with what Jamie and Angelica have said. Generally speaking, if I have a client who's going to plead guilty in exchange for probation, we're going to get all the terms and conditions of probation beforehand. And I'm going to sit down and have a conversation with that client about what the terms and conditions mean. And I'll say something to the effect of, it's very important that you tell me now if there's a condition that you can't comply with. If it says you got to be home between the hours of 8 p.m. and 6 a.m. and you work the night shift at the meatpacking plant, we got to talk about that, right? And so if you had a lawyer and the lawyer didn't have a conversation with you about the terms and conditions of probation, it's possible that could be attacked as an involuntary plea. The idea that this is important to you, that this is the medicine that you take and that you wanted to keep taking it while on probation, that's something that you could potentially raise. I don't know at this time if that's true. Probably have to do some further inquiry. But in terms of medication, when medication is also a controlled substance in some way, probably what the court's going to want to ask is, is there any alternative for you? That's, not something that's going to show up on a P test or whatever.
Right. And to answer the question in the chat, I don't purport to have read every law in Texas, despite starting my practice 5 years ago and Jamie telling me I need to sit down and read every law. But I have never heard of any law that talks about both probation and any prescription medication, or anything that says that every probationer has a right to be on a certain prescription medication. In fact, I'm very aware of certain people in custody, even before they're convicted of a crime, not being allowed to have the medication that they've historically been prescribed in a very important and meaningful way, because that kind of a medication is prone to be dealt and used for, sold, honestly. And so that doesn't exist. There's nothing in our code that I know of that says if you're prescribed medication by a doctor, you have a right and are entitled to take it while you're on probation.
So trying to just follow up realizing that I've got two places to get questions from. Let me move on, guys. And a shout out to Jesse Williams, longtime Texas NORML member. See him at Flamingo all the time when we used to be there. I think the issue everyone is wondering is that Texas does prescriptions. What does the law say on prescriptions? Can a judge say and order someone to be on different medications, even if a doctor says those don't work, and this special one does, and the state allows the prescription? Is there a code for prescription meds and probation? I'm actually going to take a little bit of a different sort of angle on that question to try to answer it. And what I'm going to do is I'm going to kind of rephrase the question so I can come up with what I think is an unfortunate answer, but a true answer. The issue isn't that the judge is going to write down on the conditions of probation, do not take this specific medicine. What they've done is they've said, do not use any controlled substances, which includes marijuana. So what happens is it's almost back, it's similar to that harmless error that I was talking about before in an odd way. That from a legal standpoint, that's not true. But you then go into your probation officer's office and you pee dirty for THC, they send it to the judge to have a hearing. The question becomes preponderance of the evidence by 50%. Does the judge believe that this could be THC? It's way below beyond a reasonable doubt, right? How is your lawyer? Because here's the deal, guys. I know this is stupid for them to be afraid of this, but they're concerned apparently that when you're taking your legal THC that you need for whatever you need it for, that you're also smoking a joint that you shouldn't be. And you can't prove that you didn't smoke a joint. It's almost, when you're talking about probation revocation situation, similar to that, situation where you have to show that that's not it, right? You're still not proving that you didn't smoke terrible illegal marijuana. Maybe you did that and the THC. Any thoughts on that, guys?
Well, I agree with everything you're saying, Jamie. I guess I would just add on to it that I am surprised to hear in some of these questions that there seems to be judges in Texas that are saying, I'm going to decide which of your medications you can and cannot take, and issuing specific orders that this legal THC I'm not going to allow you to take while on probation. Right. And so I am unaware of any law that precludes them, that stops a judge from telling you what medication you can take while on probation. They have very broad power while on your probation to control what you do in order to keep you and the community safe. If I were the lawyer of someone that the judge told, I'm not going to allow you to take your prescription THC, I would have a lot of filings and things to say about it. But as the law stands, I don't see anything that would stop them from specifically saying even your legal prescribed THC you can't take. And like Jamie's saying, I would guess that the judge's reason for saying your prescribed THC you can't take is because they want to be able to monitor whether or not you're taking illegal THC as well. I would guess that would be, I don't know. I think it's crazy that a judge would do that. But if y'all are saying the judges are doing that, I mean, judges do crazy things.
And Rob, I can't remember how crazy it gets appealing a deferred adjudication plea anymore, because again, I've been out of that part of the business for a while. But pretend you could get over that, okay, or whatever, and you got this in front of the Third Court of Appeals here in Austin, and the evidence is essentially, we know there's a drug test, we know it's THC, we know some THC is a violation of probation. If they saw that and said, Judge, fill in the blank from Travis County Court at law number whatever, revoked this person, isn't it almost unthinkable they would reverse that?
They would reverse it, or they would?
Yeah, that they would reverse it. If the judge revokes on that and you somehow manage to get that in front of the Third Court of Appeals, I think I'm right that might even be difficult to be heard substantively on. But skipping that issue, assuming that they addressed your issue, and I don't know, what would you, I don't think this has been litigated, but I warn the people that I'm down on the courts and not sure that they're going to come up with the right answer. And we're going to go to Jana's question next. Yes. But sorry, Rob, I was just responding in chat. I didn't know if you.
I guess it's like
Oh.
opioids. I mean, have y'all ever heard of people being ordered not to consume
Yes.
opioids despite
Yeah.
prescription on probation? Then
So yeah, that's an example I was going to give.
Yeah.
Sometimes we have clients that, they're being prosecuted for making too many requests for opioids, right? Going around to different doctors, but no one disputes the fact that they have chronic pain and that they need opioids to treat their medical condition. That's where it gets really tricky, right? Because if you're the judge, you have this idea that this person is abusing the system or maybe even getting some opioids to sell on the side, and you don't want that to happen. But at the same time, do you want to deny someone the prescription that their doctor says they need? So I think it is a difficult issue. And the only other thing I'll say is to go back to kind of the initial question. If the question is, can a prosecutor or can a judge do something in the criminal justice system, the answer is usually yes. If the question is, should the judge or should the prosecutor do something, that's a much more interesting question. And where we kind of make our living is where people confuse those questions, because there are some prosecutors that think I can always means I should, and there are some judges that think the same thing.
All right, I'm gonna do two more comments, and then we're gonna wrap it up. We're coming up. We're gonna end up going a little bit more than an hour, which is fine. The first one, I'm gonna just read out Debbie's and make a comment on it, and then I'm going to address Jana's question. From Debbie, my 22-year-old son decided to forego probation for 5 years for a THC conviction. He is in state jail sitting out 6 months instead of the hassle of probation. First off, I feel required to say I'm sorry that your son had to make that choice in the first place. But that can absolutely be the correct thing. I've got people, most of my marijuana clients can probably, that's a felony. So the probation period being 5 years. Unfortunately, some people are better off taking a little bit of jail now. 6 months, is that a little bit? Instead of 4, 5, 10 years later. I don't know the degree of the felony or anything like that, but I'm sorry that your son had to make that decision, but I understand why those sorts of things happen. And now let me read this last question. Hi, my name is Dr. Jana Sharp, scientist in medical cannabis. It may not be a relevant question. I already know it is because I've read it. For attorney panelists, but do you plan to open any panelists to discuss usage, medical marijuana for real patient treatment, cancer, PTSD, etc., which is still controversial, versus go to any vape shop where you can buy edibles infused with THC? Is there any space to accommodate real scientific research for various cannabinoids for marijuana for the patient which needs treatment? So let me start off with this one. So as still being classified as a Schedule I controlled substance, worse than cocaine, marijuana, it used to be the marijuana couldn't be studied. There's some slight relaxations on that, I think, that aren't worth mentioning, because generally speaking, one of the favorite things of the drug warriors to say is, well, we need to study it more. There aren't enough studies. Well, they're either have no idea what they're saying when they're talking about that, or frankly, more likely, many of them, if they're actual politicians, they're being very disingenuous, because the law prevents studying marijuana in a controlled scientific manner, in the manner in which it should be. A lot of our studies come out of Israel. A lot of the world studies, a lot of the studies that we have actually come from other nations. The US is getting a little better on that. And Texas NORML does also, besides a monthly meeting for an hour, we do put on weekend seminars that are much longer, that have speakers that come and talk about these sorts of things. So we'd love for you to get in touch with us. It sounds like you're experienced in that field, and yeah, that's what we're here to do, is to make it so that people can use the medicine that they need without even worrying about going to prison. All right, guys, Rob, Angelica, I super appreciate y'all being here. Do you have any final comments before we wrap it up? All right, that sounds like it's oh, sorry, Rob, go ahead.
Just thank you for having us. It's fun.
Of course. Yeah, it was fun for me too, guys. I appreciate it. You guys can find Texas NORML on the web. We're also here every first Wednesday of the month. At some point, we're going to be going, I don't know about COVID and when things will happen, but things will get back to more normal and we'll start having in-person meetings as well. We are having some in-person events occasionally, depending on the situation. So look that up online if you would. And we appreciate everyone being here. Thank you to my guests for coming, and good night from Texas NORML. Thank you, guys.